Shalom, Shalom family. It's your brother Omani Yamakai. Before I start, I'd like to give all thanks to the Most High, Yahweh Bahashem Mashiach, Yahweh Shai Barakatah. Today I want to touch on color of law and what that is. I also want to touch on a democratic form of government, a republican form of government, the difference between the two. All right, matter of fact, that's where I'll start. A democratic form of government is basically a majority rule government. Okay, for an example, if 51% of the population wanted to make drinking orange juice a law or against the law, then that would be the law. If 49% of the population voted against it, it wouldn't make a difference, and they'd be forced to adhere to that law, or else. And I don't think I need to tell you that that's unfair. That half the population is being forced to adhere, or else. So that's a democratic form of government, to where the majority rules. Okay. And more often than not, the majority is virtually half the population. All right. Now, a republican form of government is a government that operates off of a set like group of rules, like laws, a set of laws. For example, the Constitution. The Constitution would be, adhering to the Constitution, strictly to the Constitution, would be a republican form of government, where every law would have to be in adherence to it, in accordance with it. And that's what they say this government is based off of. But we all know at the same time, in the next breath, they'll tell you it's a democracy. So that's why I'm making this video, to give you guys a clear understanding of the differences and what form of government we're operating under today. Another thing about that too, in these government-funded schools, they basically forced us to pledge allegiance to a republic, not a democracy. Okay? And you can't even find the word democracy anywhere in the Constitution, not even once. But you can find republic. As a matter of fact, Section 4, or Article 4, Section 4 of the Constitution for the United States, it actually states that the United States is supposed to guarantee to every state a republican form of government. Okay? And that's important to know, especially when we're going into what colorable law is. Okay? Because if you can understand the two different types of government, color of law, it'll be way easier to understand. Okay? But now let's go into color of law. Color of law refers to an act done under the appearance of legal authorization, when in fact no such right existed. Okay? It's done in the appearance of legal authorization. All right? And it applies when a person is acting under real or apparent government authority. So it can there's real police officers acting under real government authority, that are enforcing these laws, and they appear to be real. And they appear to be of legal authorization because you got legally authorized law enforcement officers actually enforcing them. If you're deprived of any of your rights under a color of law, that's actually a federal offense, and that's what I want to be getting into today. That's the whole purpose of this. All right, that's Title 18 of the United States Code, Section 242. It's actually titled Deprivation of Rights under Color of Law. And I'm going to go ahead and read that for you guys. I'm going to read it verbatim the first time, then I'll read it again, where I will omit certain things that I think is just confusing when you're trying to understand what this is. Title 18 of the United States Code, Section 242, Deprivation of Rights under Color of Law, reads as follows. Whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race, than are prescribed for the punishment of citizens. Now that part, when I read it back, I'll be omitting that because I just think that's confusing. A deprivation of rights is a deprivation of rights. It doesn't matter why you deprive me of my rights. You deprive me of my rights. The reason doesn't really matter. And I just don't want to mention color and race because it would be easy to get that misunderstood and just be under the. I can see where one would think that a deprivation of rights in the color of law had to involve color or race or racial situation. After reading that part there, so I'll omit that when I read it back. Sorry, I went off. Pick it back up. Then I prescribe for the punishment of citizens shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping, or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title, or imprisoned for any term of years, or for life, or both, or may be sentenced to death. All right, now I'm gonna read this again and break it down. All right, this is Title 18 of United States Code, Section 242, titled Deprivation of Rights under the Color of Law. All right, and it says, whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed, meaning if they end up beating you up or you get in a scuffle with them, if any of that is committed in violation of this section, or if such acts include the use or attempted use or threatened use of a dangerous weapon, when they got their guns drawn or whatever, when they attempting to apprehend you or whatever they want to call it for any of these colorable laws, okay? If it includes the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title, or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping, would be under the color of law. If you're arrested under the color of law, that's unlawful. That's not a real law. So that wouldn't be considered an arrest. That would be a kidnapping. So it says if any of these acts committed in violation of this section, or if such acts include kidnapping or any attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title, or imprisoned for any term of years, or for life, or for both, or may be sentenced to death. Okay. So what that means is, under the color of law, if a law enforcement officer is trying to apprehend you or arrest you under the color of law, and they use force and end up injuring you, and they have their guns drawn, and they actually take you under the color of law, these people can be sentenced to any term of years, or for life, or be sentenced to death, according to Title 18 of the United States Code, Section 242. You can go check that out for yourself if you like, but that is the law. Now, so we can get a deeper understanding of what color of law is. A lot of the laws on our books today are actually colorable laws. So it'll be painstaking for me to sit here and try and list them all for you. But what I will do is go through the Constitution, because the Constitution is the actual law. That's the supreme law of this land. Okay? So all laws passed contrary to that would be considered colorable laws, because they're laws that appear to be law, but they aren't law, because they're not supposed to be in opposition to the Constitution. So what we're going to do here is go through the Constitution just a little bit to give you an idea of what actual law is. Just give me a second. understanding what this says real quick. Alright. Now, let's see. Now I'm gonna skip the articles and go straight to the amendments. It'll be a lot easier. Let me start with the Second Amendment. The right of the people to keep and bear arms shall not be infringed. All right. So that's a law, people. That's the supreme law of this land. So any law made contrary to this, that contradicts this, would be considered not actual law. It appears to be law. It's actually in contradiction to this. So that would be a color of law. So the government requiring that people have a license to bear arms, that's an infringement on your right to bear arms, because you're free to do so. And when you're free to do so, that means you don't need permission from anyone. You don't need a permit or a license to do so. And you can't be prosecuted for such. You're not supposed to be, but you know the way the law works. Failure to object is consent. All that good stuff. Yeah, so just to give you an idea, let's drop down to the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by oath of affirmation. So that's pretty clear cut. You don't have to give them anything. They can't just search your house and take your things without it being warranted by probable cause and supported by oath or affirmation. Anything outside of that would be color of law, because that's actual law. Okay, in the Fifth Amendment, okay, no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. And I like that one particularly. I like that one a lot. I like all of them, but I like this one a lot. Okay, that means they can't take your property. They can't take your property or your freedom without the due process of law. Now, so if, say for instance, you were pulled over and you were presumed to be driving without a license, or accused of driving without a license, that is not a law. Okay, and they can't take your property because of it, because you didn't go through the due process of law for them to be able to take your property. That's what the Fifth Amendment says. They can't take your property without the due process of law. And that actually correlates with the Fourth Amendment right above it, where it says they can't search or seize any of your property without it being warranted by probable cause and supported by oath of affirmation. Yeah. So, and even anyways, traffic situations would be civil situations. And it was ruled already in the U.S. Supreme Court that every case must have a plaintiff alleging personal injury that's fairly traceable to the alleged unlawful conduct of the defendant. So in this case, in any traffic situation, where's the injured party? Let me just find that case and read that into the thing verbatim for you guys. Hold on. Okay. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct. And that was ruled in Allen versus Wright in the U.S. Supreme Court. The injury alleged must be distinct and palpable, and not abstract or conjectural or hypothetical. That means there has to be an injury in fact. There can't be or there's a possibility you can hurt someone driving without a license because you don't have a license. You don't know how to drive. You can hurt someone in the street. That can't be the reason for them to penalize you for anything in a civil situation. Okay, and it's just that simple. Like it says here, it can't be abstract, conjectural, or hypothetical. That's hypothetical. The fact that I probably could injure someone driving without a license. Yes, hypothetically speaking, I could. But that can't be a reason for you to penalize me for driving without a license or traveling without a license, however you want to put it. And that's the case law to support that. And let me see. And now regarding criminal, how does criminal fit into this? First of all, almost all criminal laws are statutory. And our Constitution, the New York Constitution specifically, Article 6, Section B says that all of these courts are supposed to be courts of record. I touched on this in my last video. If you didn't watch it, you probably should go check that out. It was just 7 minutes. But Article 6, Section B of the New York State Constitution says that all of our courts has to be courts of record. And when you look up the definition of a court of record, it tells you that a court of record is a court that proceeds in accordance with the common law. And then you go and look up the legal definition of common law, and they tell you that common law is that law that is contrary and opposite to statutory law. So that means, in so many words, short story short, these courts are not supposed to be operating any type of statutory capacity, according to the Constitution. So anytime they got you in these courts and they're charging you with a statute, when they're supposed to actually be proceeding under or according to the common law, then the procedures would be unlawful, because you would, and especially if they result in a judge sentencing you to time in jail or prison or something like that, or whatever he might sentence you to, or even him just compelling you to come back to that court. The proceedings are unlawful at that point. Once you figure out, or once they put on a record that they're charging, they have you here trying to charge you with a statute in a court that's not supposed to be operating according to statutory, according to under any type of statutory capacity. Okay, I want to make sure I covered everything here. Acting under color of state law is misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state law. Taught them how to lock us, taught them how to pop us, even gave them a taser and taught them how to shock us, stack us up in them cages, they taught them how to stock us, but what they can't teach them faggots is how to stop us. They trying to watch us, time is money, they trying to clock us, they trying to knock us, make it big and they try to pock us. That was big and pock up, think the cops said big and pock up, quick to give a cop the middle finger to lift my cock up. You got this though. Still awakening, people. Play no game. People, get your pen and pad, cause a nigga about to teach you. And you can do the math, you gon' find nothing equal. Read the books from the past and they say that we the heroes. Niggas been sitting on their ass, they been selling out the people. I don't wanna say no names, say no names. So I ain't gonna say no names, say no names. What? Offensive. I speak the truth, don't give a fuck who I offended. Fuck you. Bitch ass niggas only wanna fuck with his Kendrick. Fake ass niggas, I am not the one to pretend with. Pull up, hop out, guns swinging with fringes on me. I don't wanna play no games, play no games. So I ain't gonna play no games, play no games.